thrilled to be here today with Jeff Goldman, who is co-founder of Build. He is my father. We co-founded this together about 8 years ago now, which is pretty wild. He also runs Goldman and Partners Immigration Law in Boston. We wanted to have this conversation today because I've been on the phone with a few companies which have really misunderstood some of what is going on in the H-1B $100,000 fee proclamation world right now. I think this is the conversation that's happening constantly in our space. We're talking and analyzing about what this $100,000 fee means and when it's paid and how it's paid. But a lot of companies are receiving this information as a blanket fee and a blanket statement that all folks have to pay this $100,000 for each H-1B that they are filing. So today on the agenda, we're going to start to really dive into what the $100,000 fee means today, what litigation is going on. And we just learned in a webinar a few days ago from Jesse Bless, who's the lead litigator in the case, what is happening right now in litigation and what it could mean for companies. And then we're going to dive into what the realities are for backup plans and what the lottery is looking like this year, given some of the weighted system. So Jeff, if you could just introduce yourself, tell us what's going on in your world related to H-1Bs, we'll go from there.
Thank you, Danielle, and welcome everybody. So I'm an immigration lawyer. I've been practicing for 31 years, strictly employment-based immigration. I've probably filed 10,000 H-1Bs over the years or supervised other lawyers at my office filing these H-1B petitions. And things at our office are very busy. We're getting calls every single day about new people who want to enter the lottery. It's not too late. The lottery registration period has opened and it goes until March 19th. So it is definitely not too late to enter the H-1B lottery. Most of the questions we're getting these days are about the lottery and not so much the $100,000 fee, because a lot is already known out there in the public about the $100,000. But let's start with that and summarize what is that fee and what's happening in the moment with all the litigation regarding that fee.
Yeah, Jeff, one of the crazy conversations I had this week was with a pretty, mid to large size company, and it's a partner of ours. And they were under the impression that $100,000 fee applied to all of their new H-1B registrants. So if you can just really simply say what your reading is at this point and how Ayla is reading it, that would be a good place to start.
The $100,000 fee does not apply to most of the H-1B petitions being filed. It is only assessed if the foreign national is physically outside the United States at the time the petition is filed. The truth is, most H-1B petitions are filed for people who are legally inside the United States, and most of them are in F1 or J1 status, and they're maintaining their status. They're legally here. And if that's true, there's no $100,000 fee because the person does not need to be outside the United States to gain H-1B status. So what is clear is that the $100,000 fee is not need to be paid if the employer is requesting a change of status, meaning the person is inside the U.S. in F1, J1, or any other legal status, and they're changing to H-1B. It does not need to be paid if they already have H-1B, and the current petition is just to extend the H-1B or to amend the H-1B, no $100,000 fee. Now, the danger is this. The foreign national could be inside the United States, and you're filing a request to change their status from F1 to J1. But the ultimate decision from USCIS is that there was something wrong with the person's status. Maybe they fell out of status. And now USCIS says, well, we'll approve the H-1B, but we're not going to approve the change of status because that foreign national was out of status. So we'll approve it and send the approval to the U.S. consulate in her home country, and she can depart the U.S. and get the H-1B there. No problem. Just please pay the $100,000 fee right now. So It is true that is really assessed against people who are right now at the moment you file outside the US, but it can also be assessed if the person is somehow found ineligible for a change of status and they
Right.
must depart the US to get that H-1B.
So, Jeff, to clarify, for folks on a TN, which is someone just wrote in the chat, a TN, for companies that have folks on an expiring J1, for folks that have a L1, they need to change status to H1B. These are all fine to file in the US with no $100,000 fee. And then what if they go travel?
You,
Because
you,
they have the change of status approved, they don't have to pay the fee when they re-enter. Is that
well,
correct?
that's the key. That's the key word, Danielle. If it's approved, yes, you can travel. But if it's not approved yet and it's still pending, travel outside the US while an H-1B petition is pending will void, it won't void the H-1B petition, but it will void the request to change status. And that will result in the government assessing a $100,000 fee. So do not travel until it's approved. Now, if you're entering the lottery and you win the lottery, and your employer then files the H-1B petition prior to June 30th, because for the lottery winners, June 30th is the deadline to actually file the H-1B petition. And let's say it's approved in July or August. The actual date that it's approved for is October 1st, because that's the first day of the next fiscal year. Well, what happens if it's approved in July or August? Now you depart the US and you want to come back in September. Well, you're not H-1B until October 1st. So if you're going to come back in September, you have to have a valid F1 visa already in your passport, and you could enter on F1 to finish OPT. But we don't recommend this. This is
Yeah.
overcomplicating things.
Yeah.
You really
And
should not be
that could lead
traveling.
to problems at the consulate. They could say, well, you only have 1 month left on OPT. We're going to
Yes.
deny your reentry,
Yes.
even if you have a pending H-1B. So for employers on the call, and I see many of you, it is not advised to have folks travel before the approval of their H-1B, even if they are change of status, even if they have a different, even if there is a different status that is expiring imminently. Get the approval on the consular on the change of status petition, and then, Jeff, you're saying they can go travel, they can get their visa stamp, they can re-enter, but they have to have that approval in hand.
But they have to re-enter on H-1B, because as Danielle just said, it's very dangerous to try to re-enter on another status after you've been approved for an H-1B to start October 1st. So
Yeah.
it's not enough to just have that approved. It should be approved and really be after October 1st or on October 1st that you enter the US in H-1B status with an H-1B visa in your passport.
Right. So we're in a really interesting moment right now. We had a webinar 2 days ago, last week with Jesse Bless, who used to be your colleague, Jeff, and work for you. He had a lot of really wonderful things to say about your firm and how you pulled him out of working for the US government. And now he's one of the leading litigators in the country on behalf of foreign nationals and companies that are dealing with immigration challenges. And he is leading some of the most hopeful litigation around the $100,000 fee against the $100,000 fee. He says, and he told us that the reality is, he believes he has a great case for why the government is not legal in having this $100,000 fee, because one of his reasons is the timing of the payment. The payment is due at the time of filing. We've been asked to do the $100,000 fee payment on behalf of some of our clients at Build, and we would have to pay that up front when we file the petition, not necessarily after approval, not upon entry. And it's really interesting because that's not really a State Department decision. That's the USCIS's decision and mandate. And if we're calling this an entry fee and something that is really the responsibility of the State Department, this is what he's arguing is actually more like a tax on employers. And so that's part of his argument that's being made. He thinks he's going to be successful. We will know an answer in the next couple of weeks, it seems. So how are you advising clients in this moment? I mean, the lottery is right now. Should they be filing H-1B registrations for folks in hopes that this litigation is successful? What are the pros and cons there?
Okay. Well, once again, the fee would only be due if your foreign national you're applying for is outside the United States. So if your client is inside the United States in a valid F1, J1, or TN or L1 file, you're not affected by the $100,000 fee.
If they're
But for,
inside the States, yeah.
for those who are outside the United States, we are advising them to also enter the lottery because there's a high chance, I can't say definite, but a high chance that a court will invalidate the $100,000 fee before you ever need to pay it. Again, as Danielle just said, that fee is due upon the filing, not entering the lottery, but upon after you've win the lottery and you are filing the H-1B petition, that's when the fee would be due. But the deadline to file that petition is June 30th, and I think there's a strong chance that a court will invalidate the $100,000 fee. It's completely illegal. And the one decision that's come down from a federal court makes no sense at all because they sided with the government. Here's the bottom line. We all agree that the federal law permits a president to impose any restrictions on the entry of foreign nationals deemed detrimental to U.S. interests. Now, whether you think an H-1B worker is detrimental to U.S. interests, we can debate that for hours. But the fact is, this is a restriction on the entry of foreign nationals, yet the government is charging the fee well before the entry. They're charging it before the petition is even adjudicated. We don't even know if the petition is going to be approved. And even if it is approved, we don't even know if the foreign national is going to enter. So this is not a fee to limit entry. It is a tax on even filing the petition. And the idea, as Jesse Bless is arguing, the idea that this fee is paid not to the State Department, who regulates entry by the issuance of visas, but the fee is paid to USCIS, which has absolutely nothing to do with the actual entry of foreign nationals, shows the true color of what this $100,000 fee is. And I think even the litigation that's already lost, I think an appeals court will overrule that and stop the $100,000 fee. And even before or after they do that, I think Jesse's litigation is going to win. Yes, we are advising people, even if your foreign national is subject to the $100,000 fee, we think it's worth filing. And this is especially
Worth registering in the
at
lottery.
least registering in the lottery. Now, let's just quickly talk. What does it cost to register in the lottery? Well, the government filing fee is $215. And if you want a lawyer to do it for you, to registration, my firm is charging $1,000. I think that's the average around the country. You could also do it yourself. And I just want to quickly talk about that. For years, I have said to hundreds of companies, you don't need to pay me to register in the lottery. You can do it yourself. This year is different, as we're going to talk about in a minute, with the new lottery system where they are favoring lottery registrations with the highest salary. This is a new ballgame. This is not something that a non-immigration lawyer can just sit there and quickly figure out strategically what is the best job title, which SOC code, that's a standard occupational classification code, goes with that job title and job description, and then which salary is the right salary for that SOC code. We're doing this every day. So I do think this is the 1 year I'm recommending that you do use a lawyer. So my firm, $1,000 plus the $215 filing fee. Almost everyone I'm talking to is saying that's well worth it, even if the foreigner's outside the U.S. and you don't know if you're really going to file the petition yet if you win the lottery.
So companies are hedging. Many companies you're working with are hedging and saying, in case the litigation is successful in the next few weeks, we don't want to have missed this lottery season completely, because then at least we have the option, if the litigation's successful, to file the petition, and that has to be filed before June. And so there is some time for this litigation to be successful. And as we said there, we should know in the next few weeks. And Jesse says he has a very, different judge, Bush appointed judge for his case, which is different than the judge that the Chamber of Commerce had, who was a bit more conservative potentially. And so we don't know what's going to happen. I think it's a really interesting consideration. There's a world where we see the total number of registrants down so significantly. And then if the litigation is successful and the $100,000 fee goes away right after the the lottery occurs, there's going to be a lot of companies that are trying to figure out what to do, right? Because they missed the lottery, they didn't have the registrations in, and now they have a whole nother fiscal year until they can go ahead and re-enter. That's a really interesting perspective for anyone on the call who's considering entering or thinking about those fees. Jeff, let's talk about that wage-based lottery one more time and just, how you're advising clients. I think we've, for the first time ever, this is requiring you to actually put in the wage right into the registration up front. Usually that was done after. So what are those changes looking like from your end? You said this is the first time you really recommend having a lawyer. Why? What is the consideration that companies are, well, the conversation between you and companies up front and the evaluation that you're doing that hasn't happened in the past?
Yeah. This year, for the first time, the lottery registration requires information on what is the job title and job description.
Bless you.
My goodness. Okay, excuse me. What is the job title, job description? Which SOC code do you think most closely relates to that job title and job description? And then based on the SOC code, which salary level does that equate to using the Department of Labor's salary survey? So the strategy is this. A job description could fall into more than one SOC code. And an experienced lawyer can look at a job description that you've titled software developer, and a lawyer could say, okay, yes, it could be a software developer, but it actually, almost every duty you have in there is the same as a computer systems analyst. And that is a different SOC code. And in most cities across the United States, that SOC code has a lower range of salaries. And so you might be able to offer a level 4 wage instead of a
Mm,
level 2 wage by switching the SOC code you're using. So just to back up for a second, this year's lottery is a weighted lottery. If you have a better chance of winning, if you're using a level 4 wage according to the particular SOC code, than if you're using a level 2 wage. This is the first time that's happened. Before, this was a random lottery, and it didn't matter what wage you were offering or which SOC code you chose. You had the equal chance as everyone else of winning the lottery. But this year, you have a better chance if you choose the level 4 wage, and then the next best chance of the level 3 wage, down to the level 2 and the level 1 wage. So there is a lot of strategy right now at the moment that you are entering the lottery. And here's, Danielle, I think you were probably going to ask this question, but I want to just bring it up right now. You must, if you win the lottery, you must use the same SOC code and wage that you use in the lottery when you file the H-1B petition. You
mm.
can't change it. So you can't try to game the system by offering a level 4 wage in the lottery, and then you win the lottery and you say, yeah, but it's really a level 2 wage that we want to promise to pay. It doesn't work. They will catch that immediately and they will deny the H-1B petition. So that's why it's just so critical to have the proper wage.
It's the analysis is so important this year. And I think, and by the way, this has been a debate. Even we got a question on this in the last few webinars. There are a lot of attorneys out there who are advising differently and are saying, doesn't matter, we'll put the level 4 wage right into for a certain specialty occupation right into the registration and then their petition. And so where do you think there's room for audit? Like, what does this ultimately look like and why is it important from your analysis that these are matching?
I think you're inviting an audit, if a full audit, and mostly a denial if you end up using a different SOC code or salary in the H-1B petition than you used to register for the lottery. I think they'll audit every single one of these to look further deeply. And if they find this is an opening up to them accusing you of fraud, and don't do it. That's all I can say. You got the time to be smart and strategic is now when you're entering the lottery. It's not later after you've won the lottery and now you're trying to figure out, is there something better you can do with the wage situation when you file the H-1B petition?
Got it. So for folks on the call, reality is this is the time for strategy. Amy's saying she worked with your firm. Amy Avera has worked with your firm, Jeff, on doing this kind of analysis and says the lawyer's been really helpful in doing just this, which is looking at the role, thinking, is there an optimized specialty occupation code where you can get a higher wage level for the same individual? This is the strategy that you should be working on with immigration attorneys, not necessarily how far can you stretch the salary for this registration process and attempt to switch it later on. That's really not what you're advising. There's room for audit, there's room for error, or more, scrutiny in this lottery cycle. Given this project firewall, it's not the time to be messing around in that way.
Right.
So I think that's really good advice. I want to take one step backwards. David Moy has asked a question, just a clarification, that if Jesse Bless wins, will it only remove the $100,000 during submission of the petition, or will it mean that if they're outside the U.S. and they enter the U.S., it's only paid if won? So, Jeff, what do you think the outcomes from this kind of litigation could be? Could it be that the government comes and says, the proclamation is invalid and therefore there is no $100,000 fee due? Or could the government potentially, or could the judge potentially say, hey, US government, the fee isn't the illegal part, but it's the time at which it's paid that's not legal. And so therefore, anyone who is filing the application doesn't have to pay the fee, but rather it has to be paid upon entry if approved. Like, would that require a different proclamation? Would that require the government to revise action, or could it be as simple as the court ruling that the fees paid a different time?
Great question. I think there's a couple of different ways this could play out. I think most courts do not proactively tell the government, our ruling is you need to switch the day you assess the $100,000 fee to the date of entry, because that would make more sense. I don't think a court would do that. They're going to just invalidate what's invalid and leave it to the parties to figure out where this goes. And if the government wants to come back and announce a new rule that it will now be assessed, the government would have to do that. It's not going to be done by a judge. So that is possible, but I don't think that's likely. Another possible way this could end is a judge saying, not only are you not allowed to assess the $100,000 fee upon filing, but actually I'm ruling that you can't assess it at all, ever, because there's no rational relationship between the president's right to limit entry to protect the United States and this attempt to limit entry of certain H-1B workers. The government hasn't made that case. They haven't argued that case. And there is no rational relationship between that. So I think there's a chance that the litigation could be the end of the $100,000 fee.
Yeah.
I think what's really likely, though, is they're going to say it's invalid the way that you've written it and the way you've collected it. It's invalid. You have to refund all of those $100,000 fees that you collected and pay it and start again. If you want to start with a new rule, do what you think. If you want to argue that it's due upon entry, go ahead and do that. But a court may later invalidate that because you have no right to do this at all.
That's right. I think that's definitely what they're arguing for. Jesse's case is not arguing for a change in the timing of the payment. They're arguing for an elimination of the payment
Yes.
altogether.
Right.
And so
Right.
that would be, hopefully, I know some folks have fingers crossed that this is ultimately deemed to be an illegal move from the president. Time will tell in the next few weeks where we land with that. So we're jumping a little bit back and forth here. It's all about the H-1B, but right now, Jeff, you work with startups out of the expert in residence and immigration for Harvard Business School, and you also work with large companies across the country. Can you just give us your take on the difference for startups and for larger companies when it comes to strategizing the H-1B lottery and the wages that folks have to pay? I've been thinking a lot about, a small startup that has 5 people has a lot more flexibility in doing that kind of strategizing because they don't have to worry about actual wages. Whereas large companies don't have as much flexibility in strategy because of that actual wage, or because they don't have as much flexibility in job title. Do you find that you're advising those kinds of companies differently? And how is it easier for you to get flexible with a startup? And what kind of restrictions for larger companies are in place based on the size that you find creates less flexibility around this creativity?
Without question, the larger companies are less flexible. But one of the main reasons is is rarely a foreign national worker coming to a large company that's going to make or break the company. And so they'd rather skip the whole thing than risk their reputation and their ability to do what they do than to try to play around with a wage issue or $100,000 fee issue on an H-1B lottery for a particular foreign national. I've spoken to many large companies who say, we're just not going to do it with this particular person. We can't. The H-1B, as Danielle alluded to, requires an employer to promise the higher of the fair prevailing wage according to the Department of Labor's salary survey, or the actual wage that they pay other similarly situated employees. And the larger companies are not messing around with that. They'd rather not do it at all than to try to get into a situation where they are opening their books to the government in an audit and showing the actual wage that they're paying all other similarly situated employees. Because once the government starts looking at that, they could start looking at lots of other things. Whereas a small company, a startup company, they probably don't have any other employees in the similar position that they're hiring for. So they already, whatever they're paying this one new candidate is the actual wage for that position. There are no prior people in that job. So they only have to worry about the government salary survey.
And for a company that has, let's say they have a team of software developers and they have someone who's coming in with a resume that could be maybe software developer, could also maybe be a machine learning specialist or something along those lines, robotics, but they really have the same profile as these other software developers on the team. Can you get creative and do the robotic specialty occupation even if they're on the same team as the software developers and that's really their job? Does it matter? Will they audit like the team and if the specialty occupation actually made sense for the team that they're on?
Question. You can take a software developer who's on a team of 5 other software developers. They're all called software developers. And this person will be doing almost exactly the same work, but they'll have a little bit of a machine learning bent. And you can truthfully file an H-1B petition as a machine learning engineer or machine learning developer. And the actual wage is just this one person. You don't need to compare her to the other 4 people who are the software developers because you're truthfully showing even the slightest difference in the occupation. You can't make it up, but if it's true that there is this slight difference, then yes, I'd have no problem using a different SOC code that might have a lower wage. I think there's definitely room for that, and I think that's done frequently. Does that answer the question?
I think it's really interesting for companies to understand the thought process, the analysis of what they can offer in terms of the role, especially as it is related to this new wage-based lottery and that
Oh,
strategy.
there was a second part of your question, which was, is the Department of Labor actually going to come in and would they audit the
Right.
difference between the machine learning developer job and the software developer jobs that you use? And are they going to come in and audit that? It's almost impossible to believe that could be true. There is hardly any audits going on ever. And although the Trump administration has promised more audits, which is fine, it's good. You should keep employers honest. And they've said there'll be more audits. We have not seen a single audit of any of our clients since Trump has saying there'll be more audits. And even if there are over the next 3 years, many, many more audits, if you're truthful, you're going to pass the audit because you have every right to use a different SOC code if truthfully the person has a slightly different job. So I just don't think there's a big risk here of doing this.
Okay, so this is obviously strategy for entering the lottery this year. We think overall, I've talked to Jeff. We both, everyone in the ecosystem knows things are changing this year. The total number of registrants is going to be down, right? Because a lot of companies are not necessarily going enter all of their individuals into the lottery, even if the cost is $1,000 a person. There's Tata Global Consultants. There's, one of the plaintiffs. There's Global Nurse Force, who enters thousands and thousands of nurses into the lottery from abroad every year. It's doubtful they're going to enter all of those nurses this year into the lottery. What are you hearing about the total number of registrants? What are the likelihoods this year of getting selected from your perspective based on, frankly, even your firm's numbers this year? how down are they from year over year? We can even extract that into a larger analysis of what the ecosystem's looking like right now.
Yeah, I think looking at the numbers from my law firm is representative of what's going to happen out there as a whole. For the last 3 years, my law firm either hit exactly or was slightly better than the national average. So I think we're a good representation. Our clients are big and small. Our occupations are all over the place. This year, we are down 35% with 10 days to go in the lottery. And we're down on numbers of registrations we are doing by 35%. So I think that's going to show there will be definitely um, the same 85,000 winners as there is every year. It's just that the percentage will be higher. You have a better chance of winning this year than in past years.
And so for those who are in level 4, I mean, we can do the math and say what's 35% less than 300,000 folks that enter annually, or in the past it's been more in some years, and understand the odds of level 4, level 3, level 2, and level 1. And there's a lot of data out there that's doing that kind of analysis. You can do it yourself as well, but there will still be a lot of level 1, level 2 folks, and some level 3, level 4 folks that are not selected this year. It's not going to be 100% selection rate. And then there's the folks who don't want to take the risk and pay the 100, enter folks from abroad. And there is a reality where the $100,000 fee stays in place. So we need to talk about backups, because I'm sure you're talking about backups all the time regarding folks from abroad who are coming in. So how are you advising companies right now on a plan B for folks that are either outside the US or inside the US and are not selected?
Yeah. So it's the same conversation whether the employer doesn't enter the lottery at all because they are scared or they don't want to, or it's too complicated, or they don't even want to risk the $100,000 fee, and those who lose the lottery. It's really going to be the same analysis. So there are alternatives out there. Not many, but there are some. One of the questions came from someone on a TN visa. These are special visas allotted to only Canadians and Mexicans. It's not every Canadian Mexican who can get a TN, but there are about 50 to 60 occupations where the treaty between the US, Canada, and Mexico permits entry to work. So if you're Canadian, if your employee or potential employee is Canadian or Mexican, absolutely, that is an option to look at.
Why are folks switching from TN to H?
The number one reason, well, there's two reasons. While TNs can be renewed forever with no limit, the fact is every time you file a TN extension, you have to prove that the person intends to depart and has not abandoned their residency in Canada or Mexico. And you might be able to get away with that once, like a 3-year plus a 3-year extension. But by the time you're extending again, it's likely the foreign national employee has lost pretty much any semblance of residency in those countries. So it gets much more difficult as years go on, whereas H-1B does not require you to prove they are maintaining a residency abroad, and it does not require you to prove they're going to depart the U.S. when they're done with their status. So that's one reason. The other reason is if the foreign national wants to pursue a green card, H-1B has dual intent. It means you can come as a non-immigrant worker in H-1B at the same time as you have immigrant intent. The intention to get a green card or permanent residency. That's not true with TN. If the government knows you've applied for a green card, they're going to deny an extension of a TN.
Right. Got it. And what about folks abroad? Are you able to from other countries? Are you advising on L1s? Like, how are you advising companies to structure L1s? Is that working these days?
Yeah. An L1 is for a multinational company, meaning there's a entity in the US and there's an entity outside the US, and they are related to each other. That's a multinational company for L1 purposes. And if you have a multinational company, the rules say you could move an employee from outside the US to inside the US if that employee has worked for 1 full year outside the US in the last 3 years. So this does not help if this is a new hire who's never worked for your multinational company. They have to have worked for 1 year outside the US out of the past 3 years. So It is an option, but yet after 30 years of doing this, I think I can count on one hand the number of employers who said, you know what, this person is so valuable. We're not a multinational company, but darn it, we're going to become one. And I will employ this person for 1 year outside the US just so I can bring them in an L1. I haven't seen that. So that's a big move for a company to suddenly become a multinational when just for one employee to get here. But if they already are a multinational, maybe the employee hasn't been outside the US for a full year yet, but maybe they're going to wait until it is 1 year and then apply for the L1. Or maybe they're going to tell the employee, go outside the US. Let's just have you work. We already have the company. Let's just have you start working from outside the US for the 1 year, and then we'll bring you back as an L1.
It's companies setting up those entities abroad for themselves to be able to structure that O1. Have you seen more scrutiny over that recently?
There's always been a lot of scrutiny over the structure and whether the companies are truly related to each other, and whether the foreign national has truly worked for the 1 year abroad. And so I have not seen an increase in the scrutiny of L1s, but they've always been highly scrutinized.
And J1s are something that you and I have recently kind of jumped into, Jeff, as we build out a new J1 program for Build. Do you want to talk about how these traditionally have been viewed in the United States and why this is an interesting moment for us to Biden's expansion of definitions of J1 categories, how that really has opened up the door for J1s for US companies with
Yeah.
when they don't want to pay the $100,000 fee?
Yes, everyone needs to look at the J1 as a possibility, as an alternative to H-1B. The J1 is officially a cultural exchange visa, which permits U.S. companies to host foreign nationals for anywhere from 12 months to years and years, depending on which type of cultural exchange program is being offered. There are internships where you can bring over a foreign national who's currently in school abroad at a university abroad, and you can bring them here for 12 months as an intern. There's trainee visas where you can bring over graduates of foreign universities to come for 18 months of training. And these training and internships really could be work, as long as there's a training or internship component to it, but they could be work. And the J1 trainee has been used often as a substitute for H-1B, but you only get 18 months. Now, the big change is that the Biden administration opened up one of the J1 categories, which is called research scholars. And the Biden administration announced private companies can now bring J1 research scholars, not just universities. And this really was a ballgame change because private companies, as long as there is a significant research component to the person's job description, they could sponsor a J1 research scholar, which can last for up to 5 years of work that the person is doing. There are audits that go on, and they will come, they, the government, or maybe a proxy of the government, which might be a J1 designated company that the State Department has to come do audits to check what is this person doing and is he really working for this company, and is there really any cultural exchange going on, or what is really happening here? So you have to be truthful, which you have to be, and that's what it is. But it opens up a new door of opportunities for foreign nationals to come to the U.S. to work.
And for folks on the call who know about Build's cap exempt H-1B program, which has been our signature program for years, where we file H-1Bs for folks any time of year if they want to participate in our fellowship program and train students through our part-time employment. This has worked beautifully for folks from outside the United States prior to the proclamation and this $100,000 fee. But now what we're doing with companies who, we're considering that and have folks that are really talented from abroad who want to come into the US, we are offering a new J1 program. And we're doing a lot of what Jeff said is really important, which is providing clear cultural exchange programming. We're providing clear training plans. We're facilitating a lot of that programming and the compliance monitoring around it, just as we've done for years with the cap exempt H-1B program. We've partnered with multiple J1 sponsor organizations that actually hold the J1 visas, but we are actually working with the companies to monitor the entire thing and ensure that it's not just approved, but that over time there's enough evidence collected and that we're facilitating the actual cultural exchange component that is so critical to the J1 program being legitimate. So that's what we're doing in the J1 space. If anyone's interested in learning more because you have talent from abroad that you want to bring here and don't want to pay that $100,000 fee, or you're not entering them into the lottery because of that fee, definitely let's discuss. It's definitely a good solution for up to a year in that J1 program, and then entering the lottery as possible. And then if not a cap exempt H-1B as possible, it really opens the door for future solutions. So definitely book some time with us to chat about that if you want to learn more. And then Jeff, I mean, some of the other classic alternatives are of course folks considering whether these individuals are extraordinary for O1, and E2s, and so pathways are open is really it's not, the H-1B has never been the only path for individuals, but certainly at a skill level with certain kinds of teams and structures, it has been like the most the most common pathway. So overall, are you feeling optimistic that doors are open for these companies to figure out some sort of solution, or do you feel like you're hitting real roadblocks here with some companies?
We feel very lucky that there are not huge roadblocks for employment-based immigration. Almost all of the Trump administration's efforts have been to stop illegal immigration, to stop family-based immigration, to stop immigration from 75 countries that they feel don't deserve to have citizens immigrate to the U.S. because their own vetting systems can't be trusted in those countries. And Trump's claiming we don't know who these people are because their systems of keeping track of criminal records and birth certificates are all tainted. He's now said, but for my law firm's clients who by and large don't come from those 75 countries, business is open as usual. And we're getting high rates of approvals from H-1B to O-1, L-1, E-2, TN. That can change. We all know enough about President Trump that if someone whispers in his ear that we should stop that area of immigration because, and they make up a reason, and suddenly Homeland Security is announcing new rules and State Department new changes on issuance of visas. It hasn't happened widely yet, and I'm always optimistic. I think look at the last time Trump was president, he lost so many lawsuits regarding immigration that he just basically stopped picking on legal immigrants. He just stopped his efforts to curb legal immigration. I think the same thing will happen here. Yes, he's won some lawsuits, but lost most of the lawsuits that have been challenging his immigration policies.
He's gotten smart with what's within his power. I mean, the travel bans being within his power has been quite significant right now. One of the very illegal things that we've seen, while we're optimistic about pathways being open for folks from those travel ban countries, USCIS is processing beyond the 15 business days for premium processing cases. And I mean, what is your thought on that? It's pretty unbelievable that that's happening, because it was not necessarily intended to be for non-immigrant visas. It was intended, from the language we saw, to be for immigrant petitions and green card applications. So this is like something where maybe we'll see another lawsuit come out soon.
Exactly, Danielle. It's just so frustrating because so much of it, the intent behind these rules have nothing to do with protecting the United States and nothing to do with what the Trump administration is discussing. There's underground reasons and underneath reasons that we're not being told. Yeah, the fact is, at the moment, the legal immigration is doing well.
Yeah. Yeah. Good. Well, we'll end on that optimistic note. Jesse Bless said in our conversation last week that you're one of the most optimistic lawyers he's ever worked with and for, but we all need a little bit of optimism these days. So I hope we were able to answer questions. If anyone else has a last minute one, you can put it into the chat right now. But we'll continue to facilitate, as all of you know, these conversations, and we send them out via our newsletter about anyone that we're meeting with. And we really do want to get good information to everyone in our networks, because it is such a confusing time. So thank you all. Sorry for the rough start, but we got there today. And I hope everyone has a great rest of your Tuesday, and we'll be in touch. Thanks all. Thanks, Jeff.
You're welcome. Thank you.